I have authority that says I can say that. I will ask that authority portion. So yes, and you will give it to me. That means we're going to be researching that issue for the court. So we can address that for the court before we get to that issue. Also, I want to address the record. So I want to get asking my mom, so that there's no concern about what my ruling was, about what I said, so everybody's still clear, okay? Why you also do parts things out, right? If y'all give me 15 arguments, I will take them one by one, very, very important, all right? So you are to make no arguments regarding with regard to imagine this room to being white or anything like that until the those situations and the take off. Understood. All right, what's the next issue? The next issue is that council was alleged that I made a statement that I would create error, and that is categorically false. I was coming to that one too, so you're with me, yes? That is false. No statement was ever made by me that I was going to create error, because one, that is unprofessional. Two, that would be a violation of my ethical duty under the state bar rules. So that is false. That no such statement was ever made. I did make the statement to Mr. Howard that errors can be made at trial, and that no case is perfect, and that if errors are made, I am not one of the counsels who is going to pretend as if whatever error the record might show that I've made, that I would not take responsibility for. So when Mr. Hiles is interpreting that to say, Ms. Mino said that she's going to create an error, that is false, and I categorically deny it, because I've never done that, nor would I ever do that. There's no need for that. I've looked at the evidence in this case, and there's need as my listening. Well, I think it's a bold statement. Oh, you'd be surprised when you see it, unless the court has already seen it. Okay. Six cameras were five, five was in the. So again, I understand word for word, right? I get it. You were advocating for your client, devil's advocate, devil's advocate, fine. But I think we also need to be very clear, because I also know, part of the reason both the officers or the driver is to get along the hard thing. But I want to give them a time. Yeah. And I wish to tell her or tell me so that I can stop, because otherwise he's not looking at her. And with her being this question, it is this way, sorry. He's not looking at this play. And then if you, so if there's a question that needs to be asked, then stop me. And then I go. Alright. That goes for the lawyer resolve. If there's any time that y'all need to stop, I'm happy to do so, but I want to make sure that Mr. King is actively participating in everything, not for everybody. Okay. So that's what I was saying. There are five cameras. And again, I'm not making a judgment call on the bill or innocent at all. But my point is, you said it is we your lead. There are five cameras. They are on camera. So that's a bold statement. I'm going to make sure that the record reflects what the record reflects. Because something is once you got some real strong lead, or once you have somebody else running the messenger. But I remember the Rodney King video that people looked at that video too, and there were different perceptions as to what people were looking at. So when it comes to what the video depicts, I think it's the duty for the state to express to the jury what they think the video depicts, and it's my duty as the defense counsel on behalf of Lindsay to express what we think the video is. I don't disagree with that, but it's my certainly understand the evidence we just the jury may hear that and interpret one thing. He may not understand that that could be passionate, and they could see that video and say, oh, yeah. So I just want to make sure, because we're talking about very serious art. And I have calculated it for Mr. Lindsay and Mr. Gibson, but I know Mr. King is facing a lot of years. I'm going to ask what, and I'm going to advise the defendants on record for their case. But I want to make sure they have very clear understanding of the choices that they are making, and have an informed understanding of everything before we proceed. So that's why it's what.
And like you said, that you're on, because one of the things we were attempting to do this morning for court, because we all had arrived early, I just want to make sure the record is clear. We were in the back with the offer had changed again from the state. And I had another meeting, 8:30. No, nobody was in here yet. Got here 8:30. Usually we can start at 6. But I assumed that, the last offer that I got yesterday was the same offer. When I arrived this morning, there's still another offer that had been conveyed, that is being conveyed to all. And for the record, I never got an opportunity to address the new offer with Mr. Lindsay in the back when we were there, because we're speaking on 3 different defendants, 3 different counsels, and an interpreter involved in communicating the information back. So unfortunately, although the court starts at 9, I never got an opportunity to address my client about the new offer that is out communicated this morning, but the offer has been moved since he and I had a conversation. So I just wanted to clear that. Yeah,
I don't know what offer is, but,
yeah. And
it is promise, so it's probably, unless y'all. Very, this case, so,
it clearly needs to be addressed at this case, because as I stated, Judge, I got it wrong. I didn't ask for it. I thought, and the rules require that if I get one, I can pay. So Mr. House's motion, I've already categorically denied. I said I was coming to a courtroom as a professional and create error. So that my client, that is the most, I'm not gonna say, that is inaccurate. That's inaccurate, and it was never said, and I would never do it. And I am so comfortable with misstate that, to this court, especially when we try to cover it. Some of the communication that Mr. House and I had yesterday were off the record communication. So we were going back and forth and sharing some things, I shared some things, because we're negotiating with the evidence, and we're talking about video, all that stuff. So him to have filed a motion stating that he's trying to perfect the record, I think it's disingenuous, and I think it's assassination of competitor. That's a whole other issue. As it pertains to the mask, I have a special. No, I'm talking about on. I want the record. Okay.
well, also, one of my first questions was certainly, my lawyers don't talk. They just want to frustrate the court. When they didn't put it as and perhaps,
Well, not necessarily, because discussions could lead to motions of limine where characters being attacked. Yeah, so I just want to show you having a conversation yesterday. I am now standing for the court. How we can construct. So can I explain to the court, I wear a mask because I have a special needs type of diabetic.
I say that, I was that with regard to the defendants and I, that was the specific and I even technical. So I have a problem with that. I see that some folks are fine, that's fine. However, when it comes to the defendant and when it comes to IP, I mean, if you all have a conversation about that before your consultation, can person say, I thought you know, because I do give a critical element, right? So that's why I brought it up, so that you all have the conversation, and so that it's not related to file and there. Number 2, so that it doesn't up on the jury that is necessary and where that's why I'm in that. And then we're so that's what I'm about the question.
Understood. As it pertains to the 2 issues, I think there's some topic after the spoken with some limitations with what and the jurors would consider Mr. Lindsay as being one. Also, the issue of me creating purposeful error is false and received, which was mass stated in 5 record. And I do not recall any other, statements that, come here.
No, that's the only thing that I was over and over.
She said she did say that I was fine.
Well, yeah, that-
And
Oh, I stand behind that. I'm glad you said that. I stand behind that.
Yeah, that's what he's doing. Alright, so, yeah. But you know, go to the offer, thank you, ma'am. Alright, so that motion is explained until I get the, briefs and or. The survey over the case file. Alright, Mr. Let me start with Mr. Steele, because that's the last offer that we got off on Monday to Mr. King, the city King, and that was one day. That's great.
So, Your Honor, that is still the offer, but it's structured a little bit different. On Monday after we had the mission, Mr. Fields,
Is this whatever this stuff?
Monday, Monday night, about 9 p.m. on Thursday, Mr. Fields called me. Said, if there's anything that you can do, this issue is definitive. Will you please get talking? Is into the door.
Well, I don't see a lot of
How is the structure of it? Yeah. So it is the plea to one count of armed robbery, which would be, if armed robbery would be commuted to time served under 1710.
So that's what y'all were conveying.
And I gave him, he also asked, in lieu of that, can I have a straight number? That would be, that said, fully served. And that, I left it at the asked for a straight number, in lieu of, because it was going to be 20 served 10 on the gang charge, which would theoretically be eligible for parole. So it wasn't, I wasn't commuting everything. I'm sort of just on. I understand. Per day. And you would still have 20 days in the game.
510 days. Meeting on the robbery. I'll tell you all. We'll have it. And especially because we're going to be fine. All right. What was the offer for Mr. Gibbs? Oh, sorry. Yes, sir.
Your Honor, just for on a project,
You're fine with looking at that, I just said,
it will be free one time on 10 years for and that will be released on all of the your debt. And that's it. 20 years, 10 years for I would for totally that great. And benefit we get. Oh. That. Sure.
once again,
My understanding. Essentially, Judge, is the same. That's correct. My understanding of the purpose of sentencing the citizen, would be essentially the same offer subject to the part on robbery. So when you serve on the gaming charge under the whole statute, so different role eligibility. In addition, you also brief the safety. But an alternative, there's also where there's an alternative would be a 27 still a subsection B departure, but it would be some number in between 1 and that would be solid. Of course, there's no probability that is we also have to see non-negotiable.
And Mr. Ferguson would register nine. All right, and what is Mr. Gibson, if he was unsuccessful trial,
Your Honor, I think these convicted of the armed robbery counts as mandatory life without parole.
if listen, I'm going to this, the doctor, like, that Mr. Gibson was looking at if he
Life without parole. Life without parole plus 75. And if he is convicted of armed robbery, it is mandatory life without parole. And the court does not have any discretion. The court must sentence him to life without parole on the armed robbery.
Mr. Gibson has 3 prior.
Correct, Your Honor.
Mr. Have you advised All right, so Mr. Gibson, you understand that you are charged with count 1, 2, yes, that's something. Count 1, violation of the Street Game Fairwood Act. Count 2, violation of the Street Game Fairwood Act. Count 4, violation of the Street Game Fairwood Act. Count 5, violation of the Street Game Fairwood Act. Count 6, violation of the Street Game Fairwood Act. Count 8, violation of the Street Game Fairwood Act. Count 9, violation of the Street Game Fairwood Act. Count 11, violation of the Street Game Fairwood Act. Count 12, violation of the Street Game Fairwood Act. Count 14, violation of the Street Game Fairwood Act. Count 15, violation of the Street Game Fairwood Act. Count 17, criminal offense. Count 18, armed robbery. Count 19, aggravated assault with a deadly weapon. Count 20, aggravated assault with a deadly weapon. And count 21, possession of a firearm with a conviction. So you understand that those are the counts with which you can talk. All right, if you keep your voice up for me, if you want to thank you, that's what I'm here. All right, so you understand that if you are unsuccessful because you have been facilitated by the state, that if you are unsuccessful in that, this is under A and C, is that correct?
Yes, Your Honor.
All right, so that means that the court has no discretion that you will have whenever you comes to your, I guess, one thing. And you understand that if you are found guilty of all of the counts that I've discussed with you, that would mean that the court would have no discretion, but to sentence you to a minimum of life without life without all because armed robbery carries that penalty of you understand that? All right, for the aggravated assaults, the court would have no authority to go below 20 years. You understand? You understand that? All right, and you understand that for the gang counts as well as the murders and the gun counts, again, it'll be the next, if you have to, any of them. You understand that the court has the force to run, the sentences consecutive, however, the court can also run them concurrent. Consecutive means each charge will follow each other, concurrent means that you can serve notice. Have you had the opportunity to discuss the state's offer with Mr. Lewis?
Good.
Do you need more time to speak with Mr. Lewis?
Good.
All right. Okay, I'll give you that opportunity, sir. You can have a seat. All right, now we go to Mr. Lindsay. Mr. Lindsay, what is the offer? Am I saying that it correctly? Okay. Maybe I should leave off.
Your Honor, somehow others.
Okay.
I'm borrowing my name.
Okay. Um, so what's the offer for Mr. Lindsay?
The offer that's made to Mr. Lindsay, was the, 20 to serve 10 on game count, as well as a 20, as well as the, 10 years community time served under the subsection E on farm garage.
Okay, Mr. Lindsay, as of yesterday, served 1,440 days custody, which is approximately 3 years.
It would be 4 come up with it.
Right, so Mr. Lindsay has served approximately 4 years. All right, and Mr. Young, I heard you say that he started to talk with you, had the opportunity.
And that's correct, Your Honor.
All right. And he's facing the unsuccessful.
He was, this is including murders, he was convicted of everything. The maximum sentence is life plus 275 years.
All right, Mr. Lindsay, you understand that the maximum penalty you are facing if you go to trial is life plus 275 years of that. Pick up for me.
Yes, ma'am.
All right, you understand that, certainly the state has conveyed an offer, and even if without that offer, you have the opportunity to go down and go. You understand? Same for you, Mr. Green. All right, so have you had enough time to speak with Ms. Leon about, your decision to proceed to bar?
No, ma'am.
All right, I will give you all that opportunity. You can have a seat. All right, let me be very clear with all of it. Okay. Advise, Mr. King was for the United States.
So I didn't count the merger last time. And if Mr. King was, convicted of everything, he would be, facing life plus 375. It includes the merger.
What did I say? I said 302.
It was, on Monday, it was 395, and then it was, there's a.
Got it. Mr. King. Sir, you'll recall the conversation that we had on Monday on the record regarding the max that we're facing. All that? Yes. Okay. And on Monday, I was advised that, the maximum you think was 9% plus. You recall that? Yes. All right. I'm sorry, permanent. Okay. They have since advised me that it's actually 5 plus 375 years. You understand? Yes. All right. I know it may seem like it's not a big difference. All right. All right, well, so, it is 9:53. I'm wondering how much time do I need to talk to clients, because I need to file the work down, and in case it does, set down, or over. So, let's see. Let's start with skill, because I think maybe a little bit more.
45.
45 minutes, that puts us at probably where that is.
Please go to.
But I also want to take this up to that, you have to very, very clear. What I would accept and stuff. Okay, and in fact, I had to change request, the videos to go forward and ten. So, we're not gonna be 45, but I was leaving from the doors.
Not up to 30 minutes.
This is
30 is reasonable.
Alright, so I will give you all, 30 minutes to, discuss everything with your client. Before I do that, let me go to the wider questions. I can start with Mr. King's, well. Why your question was, are there any objections from the defense? Standpoint, I have all the so any objections from the council to the same proposed budget? All right. All right. Objections to any of the same proposed budget?
Judge, I'm actually trying to put it.
There's any objections to Mr. Queen's proposed budget?
Yes, I do have some objections. I specifically have objections, to the questions, I believe it's 21 through 23. Apologize, Your Honor. I have objections to the questions, has anybody felt necessary, to dissolve?
Good question. This 21 is how many of you own a gun or have a gun in your home that
Oh, yes. I'm sorry. It is, 23. How many of you have ever felt you may be in danger when you see a private citizen near you in a store carrying a gun? That's critical. Because my other objection is or experience.
well, that's a different question. You said have experience, but this one is like, have you ever felt it? So I will, the question for you.
I'll answer what is going on. So, very bad case. There's fine.
All right, questions on the last one, you have?
I think you see that question just get into the literal facts of the case. I'm not having an objection to the general, does anyone feel that it is against one way or another about self-defense? If you have any objections, you feel that people have the right to defend themselves, that is fine. If there's a general question, if you get specifically into disarming people, and
That's not supposed to be clear. When they say it's just- whether it's not just clear. This is about-
I'm watching you, Judge. I'm watching.
all right, 23. How many, I just feel that, in general, who has a fear of guns? I think it's,
So they have questions about the act.
I think you can ask who has a fear of guns, but when you get so specific, if you're a private citizen carrying a gun, I think it is encompassed, and it's just the general, who has a fear of guns.
All right, something a rule has a death. Or she has the authority that says opposite. Here, the question is, how many of you have ever felt that you may be in danger when you see a private citizen near you or carrying? That question is my turn, but it's not. I do think that. All right, then walk and go as necessary. Next one.
I have objection to question 24. Has anyone ever felt compelled to disarm someone with a weapon, if they fire or knife, if it's a concern, for the safety of yourself or others? Then, that, and I feel that it's going into the back of the case. I think it's okay.
I don't know what the big argument is, if you're assuming that.
We've had two new commissions, and that's part of the record, and that's, there's conditions made in the motion. I mean,
The part.
well, I did. Okay. It leads into the, I, to your point, I will note my objection to the record. That I feel it goes into the back of the case.
So there's an authority that says that you can't ask questions that part of your part. You can ask questions that go to, certainly the fact of the case, but not something that requires the ask of your judge. So that's what I'm asking about, how does that question have to do with to judge the case versus getting their feelings, only biases in advance? That's, now, again, Mr. Steele very crafty in how to phrase that question. Had he gone further, which we agree works with where I would completely agree with you, but the way it's phrased is asking for their opinions, biases, et cetera, and form out themselves and tailor to the specific subject.
I will just respectfully disagree and I will honor the court's decision. I don't have the authority. I think it goes further in the court does.
Also, I would ask them to prove this,
Because it's the specific fact. It is, I think, a general self-defense or defense of others. Has anyone ever felt the need to defend others or themselves? When you start adding specific facts that are come out, this person who was in line was disarmed of their gun.
that's not the question. Of the specific question. Like it limited to limiting. Now, he asked this question, that's also why I said Mr. Steele, that's what I'm gonna take it. Question asked. So again, this question is, has anyone ever felt compelled to disarm someone of a weapon, such as a firearm or knife, because you were concerned with the safety of yourself? How is that question prejudging for?
I don't
It doesn't go to this, it doesn't mention anything at this point. I'm assuming what you're arguing is that. I was involved in that case, so.
I understand. I understand.
All right. So that is a rule, question 75. What's the issue or solution?
There will be the same objection, and I will. I don't have any. I feel it is good.
25. Has anyone ever seen someone disarm another person of a weapon, such as a firearm or out of concern for the safety of his or herself or, right? What's the next one?
That's the only check.
To all of this question. So let's now go to the request, the one-year questions for Mr. Lindsay. Any objection?
My objection to Mr. Lindsay's questions are in the form of all the questions, a statement first. Um,
Right, so, Mr. Lindsay, so that's Mr. Young, so you have to ask the question, so we arrange how they are asked.
So I've arranged them in like a polling, formatting, because a lot of
I
times.
understand, I find that to be confusing to the jury. So like, for instance, when you hear me ask the question, you'll hear me say, please raise your card. Because the way you have the phrase, there are people who believe that once the case is decided, that person charged must be guilty of something. If you agree or strongly agree with this statement, raise your card, versus saying, please raise your card if you believe that.
I'll change it.
Okay? Any other objections to say?
Yeah, I think all the questions to make a statement first. I think as long as they're asked, like for question 2, are there people who feel, that society focuses too much on race? I feel that is an appropriate question for one year. My objection.
It's not.
No, it is. I think it is. My objection is just to the form of the statement. There are people who feel like society focuses too much. If you agree from.
He's already said it's just the phrase, but for why that.
I don't have any other, I don't have any objections. That was my objection to this.
All right. And then with regard to Mr. Gibson's, what your questions, any objections?
No objection.
Okay. Any objections by either the defense counsel, so any other questions, other than?
I don't have any objection regarding Mr. King's or Mr. Gibson's, Your Honor, and I've had an opportunity to review the state.
Okay. Okay. Mr. Lewis?
There's no.
All right. And now back to you. Any objections to the state's, proposed budget?
No, Your Honor. There's no.
All right. All right. So, before I forget, anything else I need to pick up before we take our.
Not from the state, Your Honor.
Not from this building, yeah. No,
All right, please make sure to walk the room, please get some clear room before we come back. So, you'll. Now, Mr. King has specific positions. We feel need to turn, which is probably put him right there, but if you feel like it needs to be moved, Mr. Field, just like we started brown or the goods, and then they will.
Yes.
Okay.